Hey everyone, Shaunna Burhop with Beard & Warner. Welcome to our Spotlight series. This week we're featuring Joe Delaney with Angelina and Herrick talking about estate planning. We hope you find the information valuable. Feel free to reach out with any questions you might have after you give it a listen.
Hi everyone, thanks for joining us today. This is our first Spotlight series. We started this series to help our clients learn something new or important. It's free, it's a no hard sale, and you can watch from the comfort of your own home. So that's always fun. And you don't really have an option right now. You have to stay home. So before I go any further, I'd like to introduce the amazing real estate agents that were able to orchestrate this to happen. So first and foremost, Mary O'Malley. Wave. See Mary?
Hi, everyone. Thanks for coming.
And then Shaunna Burhop.
Hi everybody. I don't know if you can see me. I'm having technical difficulties, but thanks for coming.
And then Megan Campbell Barnett.
Hello, everybody. Thanks for showing up.
All right. And then obviously me, I'm Jason Gia. So again, why we do this is because we have amazing contacts that allow us information that most people don't know or don't have that are readily available. Again, we help people buy and sell houses, so we don't make any money doing this. But our connections and our marketing capabilities allow us to bring this to you for free. So without further delay, I want to introduce the man of the hour, Joseph Delaney, and he's in Herrick, a law firm. So Joe, take it away.
Good. Well, thanks, Jason. And thanks, Mary, Shaunna, and Megan as well for including me on this Spotlight series on the initial go-round here. I've worked with Mary, Jason, Shaunna, and Megan for many years and find them to be incredibly professional and caring for their clients. And I hope I'm the same for my clients because I like to work with the same type of professionals. So thank you for asking me to join you guys today. Today we're going to talk about some aspects of estate planning and exactly what it is and how you can benefit and how you may unknowingly need it in your life today. So estate planning is, see here. Let's see. Sorry. Usually when people come to me with questions regarding estate planning, it kind of starts with the idea that, I don't really have a lot of money. I don't need any type of plan, any fancy, costs going to a lawyer, that kind of thing. Well, what estate planning does, it's not simply about money. Okay. It's about several aspects of your life that we're going to talk about in depth today, but most particularly as we're faced with the coronavirus COVID-19 pandemic, these kind of issues are coming more to the front. The idea behind a strong estate plan is that it allays your fears. It allows you to make decisions in a rational and relaxed environment rather than under the gun at the final hour. And the decisions we're talking about are important. They're decisions that are going to affect all of us. Ultimately, we're all going to pass on, and some of us may be incapacitated along the way. And if we take the proper time and effort, we can make those days not nearly as complicated for our loved ones as they could be. So when we talk about an estate plan, we're going to talk about a lot of things. We're going to talk about first today are powers of attorney. These are documents that allow you to appoint someone to act on your behalf in the event that you're incapacitated. We're also going to talk about revocable living trusts and wills as well as we get in. So I'd like to kind of talk about powers of attorney as we get into things, because they may be the two most important documents that we're looking at now. Under this scenario, we don't know who's going to get the virus or if I'm going to get the virus or what the extent of it would be. But we do know that if you don't have powers of attorney in place for either yourself or your loved ones, things could get expensive and complicated unnecessarily. So they may be right now the two most important documents in any estate plan. And they're really important for anybody who's over the age of 18. It really doesn't matter if you have a family or you even have a job. We're talking about circumstances in which healthcare may be needed and you may not have the capacity to direct that. So the power of attorney allows you to appoint someone to act on your behalf, allows you to have an agent who can act on your finances so that your banking can be done in the event that you're incapacitated or not able to get there. And it also allows you to appoint someone to make decisions or carry out your decisions, rather, regarding continued health care. So in these circumstances today, those documents become even more important, right? Because if you're incapacitated, the doctors are going to have to follow their protocols, which may be not what you intend. And for our circumstances where we have young adults, they're 18, and they may or may not be emancipated from the house. They may live with you. They may not. They may be going off to college. Hopefully, they're going to return to college soon. If you don't have powers of attorney in place for your children or for your young adults, in the event they become incapacitated, whether through the virus that goes around or a car accident or anything that could happen to them, the medical treatment facilities do not have to give you as the parent any type of information whatsoever. But if you have your child appoint you as their medical power of attorney and financial power of attorney, then our documents include the ability to supersede HIPAA. So you can get medical records, you can get information about what's going on with your child or a young adult, rather. I don't mean to say child, but that's how they'll always be considered to us parents, no matter what their age. So the powers of attorney today are really, really vital. And when we get into these documents, it's important not only for the powers of attorney, but also for revocable living trusts and wills, that we appoint someone who's trusted, who understands your situation. And the answer to the question of who's the ideal person is there really isn't one. It's not a one-size-fits-all category here. I have 3 children. I have one who's very compassionate. I have one who's really great with finances. Okay, I'm probably going to choose the compassionate one to make determinations regarding my health care. I'm definitely going to have the financial one do my financial affairs in the event that I'm incapacitated. So it's not a one-size-fits-all. It depends on the duties of the agent. So in a financial setting, whether it's as a power of attorney or whether it's a trust administrator, you want someone who's on the ball, who understands finances, who can make decisions in a rational fashion. And that may be it may be your spouse, it may be a child, but it should be someone who's trusted and has those skills. For powers of attorney regarding healthcare, like I said, it might be the child who's more compassionate, or directing your spouse as to how you want life-sustaining treatment to be made in the event that you're incapacitated. And those are not necessarily the same skills. And the fortunate thing about estate planning documents is that it does not have to be the same person. Okay, someone who is the power of attorney under healthcare doesn't have to be the guardian of your children. Someone who is the trustee under your living trust does not have to be the one making medical determinations. It can be if you have that person, and in most instances it is our spouse, right? But in the circumstance where it's not, and you're thinking about, well, I better have my children do it, and I've got 3 children, so I want them all involved. I don't want them to be felt like they've been left out. It sounds great, but it's really not it's really not the best method of estate planning when we get down to it. It's my opinion that when I counsel my clients that co-trustees or co-POAs, which are not allowed in Illinois, it's just not a good idea. If you trust the person to be the trustee, then trust that he doesn't need someone else watching what he does, or her or she does. And if you don't trust them, then why are you appointing them in the first place? Okay, so it's one of those things. We have successors. We always like to have a rule of 2. So if someone is not able to step up and act, that there is someone else who is there to make the call. I want to talk a little bit about the accessibility of these documents, particularly since we're still kind of talking about our powers of attorney and healthcare. And it may be that you're in a circumstance where you're elderly or you're taking care of an elderly parent, and we have the idea of a do not resuscitate order or a DNR. You may be familiar with that type of designation. These are orders that you can make that says, you know what, I've gone through a lot. I'm on the back 9 here, and I don't want heroic measures taken if I have a heart attack and I pass, or I'm incapacitated, or I'm not breathing or whatnot. I don't want heroic measures to be taken. So I create these do not resuscitate orders. And those are documents that should be readily available if you have them. My mother, for example, is at an adult care facility. She's independent living, as are many of the ladies and gentlemen at the facility. But when I go into their apartments, I notice right on their refrigerator that there is a sticker, and in that sticker are documents related to the healthcare. There's a copy of the healthcare power of attorney, and there's a copy of the DNR order. And it's my understanding that first responders are trained to look there first, because when they come into an elderly setting, the idea of a DNR is not some kind of news to them. They're going to be looking for it. Otherwise, if you're like me or Mary, Jason, Shaunna, Megan, we may not be ideal candidates for a DNR yet, but we do have powers of attorney, and we want those to be available in the event that we need those presented to the hospital. So when we make these documents for you, we create these powers of attorney and revocable living trust. We give you several copies, and we'll also give you soft copies so that you can share with your agents.
Hey, Joe, before we move on, we had a question come in about, can only one person be the power of attorney, or how do you deal with that when it's the parents who makes the ultimate decision?
Right, very good question. So in Illinois, there can only be one person at a time designated as the agent. So the parents are going to have to decide if that's mom or dad in the circumstances where we're setting up POAs for students and young adults, because there is not the ability under the law to have powers of attorney. So hopefully that helps there. So I'd like to kind of continue things, since we've gone in depth now with our discussion of powers of attorney, and it's important. I mean, these are important documents to have, as I've said, in this particular time that we're faced with. But that doesn't mean they're the only documents you have to have. And what we want to do and communicate to you is that if you have a will, that is not necessarily the best and only a document you need. So I have many clients who come in and did a will when they were younger, and now they come in and say, well, hey, I have a will. I don't have to do anything else. I'm not going to go into probate court. Well, What I can tell you is that if you have a will, you are actually assuring that you are going to go into the probate court. And a strong, effective estate plan is one that really is looking to avoid the necessity of probate court. You may have heard probate, or I got to probate the case, or you may have gone through a decedent's estate with one of your parents in the past, because this was a very common method of doing things. Today we have these vehicles that will allow us to avoid the probate court and allow us to simplify administration, reduce the cost of things, increase the time in which everything can be done. So what is probate? Probate is it's the court that hears or has jurisdiction over a certain type of case. And those are the cases regarding people who have died or people who are incapacitated. So when we talk about a strong estate plan, we're talking about one that avoids probate in all circumstances wherever possible. So in our power of attorney situation, if you did not have the power of attorney documents executed and you became incapacitated, there's nothing that says your spouse has the ability to make decisions moving forward. Without a legal definition and order of guardianship, no one has the power to make those determinations. So the bank won't let the spouse, if they're not a joint owner of the account, into the account. The hospital will be compassionate towards the spouse, but they won't necessarily follow the spouse's wishes or directions regarding life-sustaining treatment. So that's why we create those powers of attorney. We don't want to go into probate court to get that guardianship order entered, because it's time-consuming, it's very costly, and it doesn't immediately serve your needs. And the same is true with your estate. So what happens to your assets when you pass? With a will or without a will, in order to transfer real estate or other assets, there would need to be an order established through the probate court that would allow someone to act on your behalf. Again, this is time consuming, it's costly, you got to find somebody, there has to be a petition filed, there's attorney fees, and it's all open. It's all open to the public. Anybody can go down and take a look at somebody's probate estate and see where their stuff went. But with
Hey,
a little,
Joe,
yes.
a question just came in asking, does the probate court cost money? Do they charge the estate?
Yes. So what happens is there are filing fees for opening up a probate estate, is what we call it. There are time restrictions before the estate can be closed. And if we kind of take a step back and say, well, why do I have to go through this? The idea behind this probate court isn't necessarily to determine who your heirs are or what assets you own. It's really to protect your creditors. So if you owe people money, they have a chance at one last shot at getting it from you. So that's why the probate estate would be open. So there are filing fees involved in that. And there are also attorney fees. You just can't go in and act as your own, have someone go in and file a petition without counsel, without the skill of counsel, because there's a statute that has to be followed. It's not overly complicated, but it's legally involving, and that's really where the costs become kind of uncontrolled in a probate setting. So what we're trying to do with our advanced planning, our estate plan, is take that element out of it. And we do that through a number of vehicles, most particularly the revocable living trust. And in our opinion, this is the best way to transfer or distribute your assets to your beneficiaries. And what it means is essentially who gets your stuff once you pass, and how quickly they get it, and under what kind of conditions they get it. So you're able to create this trust document, and we create them for families. So there's usually the Smith Family Living Trust. So we'll have its own name, but it's an entity that we create that allows your assets to be held, the legal title of the asset to be held by the trust, while you get the benefits of the property or the asset that's in the trust. And then upon the death of the surviving spouse, which is usually what we're talking about, the trust then says, well, where do the assets go now, since this beneficiary isn't here anymore? And it just simply goes to the next beneficiary, which may be your children in equal shares. It may be your siblings. It may be a charity. It may be whatever you want it to be. And that is the benefit, really, of doing this in advance in a rational setting here. The really good news about revocable living trusts are that they can be changed. So it's not a document that's static. It's not a document that you can't ever undo or make changes to, or somehow no longer have control over those assets. So oftentimes I write revocable living trusts for when I was a younger attorney. So I would write the estate plan for my friends and colleagues and contemporaries who would be appointing their parents as the trustee, or who would be appointing their siblings as trustee. And we're coming back now and saying, you know what, I produced this kid who's this genius accountant, and I think I want him to be my trustee. And we're able to do that. We simply amend the document, take out the old trustee, put in the new trustee. So that is really a primary feature of the living trust, as well as the probate avoidance end of things. It's that it's livable. It goes on with your life. You can make things adapt to your circumstances. So it's private. It is cost effective because it's a one-time kind of payment now. It's a pay now, pay later thing. The pay later can be a problem, since really nobody is there to watch what's going on. And depending on where your assets are or how complicated your estate is, the attorney fees at the end of a will or probate case can be significantly higher. When we're talking about attorney fees in the estate planning realm, we're talking, $1,000 to $2,000, somewhere in there. It all depends on the time that has to be put into circumstance to create them.
Hey, Joe, before we go on, we just wanted
Sure.
to encourage people, if they wanted to ask questions, if you've not used Zoom before, down in the bottom, you should see a Q&A. So we're going to monitor that throughout the rest of the presentation. And then at the end, we'll also have the ability to do the Q&A as well.
Terrific.
And one more thing that just came through, we did have a question just come through that says, my father-in-law had a trust, passed away, and left everything to my mother-in-law. She died within 3 days, and their property never made it to the trust. Can a trust belong to two people to avoid this problem?
Well, yes. So depending on the complexity of the estate, we create usually one family type of trust. So in this circumstance, there would have just been the your father-in-law's trust. In which case your mother-in-law would have been the primary beneficiary, and then upon mother-in-law's death, it would have gone to the subsequent beneficiaries. One thing that we see not uncommon is that a lot of attorneys like to write these trusts, but they don't like to fund these trusts. So you can create this beautiful revocable living trust with the best beneficiaries and the best trustees in the world, but if the trust is not funded, if the trust doesn't own anything, it doesn't have anything to pass on to your beneficiaries. So that's a key element, and I think it might be what happened in that particular circumstance, that father-in-law's assets were never really put into the trust, so mother-in-law never really had anything as the subsequent beneficiary. So it's important not just to create the trust, but it's important to fund the trust. When we create these family trusts, and these are circumstances where your assets are under $4 million, because that's when beyond $4 million, we have to take into account some estate tax planning. And those are usually ones that I ask a colleague to come in and counsel with, because that's a little bit more complicated. I don't want to make a $4 million mistake. So,
all right, Joe, we got a couple more questions coming in.
Terrific.
Did you mean $1,000 to $2,000 for attorney fees during probate, or fee to make a revocable living trust?
Good. That's the fee for revocable living trust. Generally, fees for probate begin around $5,000 just to take the case. And that's a pretty good rule of thumb around the northwest suburbs. So, and then it's just a matter of how much time the attorney puts into the probate, excuse me, going into court, establishing the estate, and then being able to close the estate. So it's an open-ended event in terms of attorney fees. In a probate matter, it's a defined amount under the drafting of the revocable living trust.
All right, and then another question is, so all assets should name the trust as the beneficiary, and then the will determines who inherits the assets?
Well, that's a good question. So that isn't necessarily the case. So when we create the revocable living trusts, those are going to be the primary elements of distribution of assets. Our will is there as kind of a safety net and to appoint guardians in the circumstances where we have minor children. That's where the will aspect of things is going to take place. But getting a distribution to a beneficiary will all take place under the revocable living trust. And in order for that to happen, the trust has to be appointed the owner of assets. Now, it doesn't become the owner of every asset. So, for example, your 401k, your IRAs, those are documents, or those are assets that we generally do not put into a trust, because by changing the ownership, we've created a taxing event, and now all that tax that you've been deferred for years comes due. Documents such as life insurance, unless we've created a circumstance where we want that life insurance to fund aspects of the trust, those are assets that can be passed on outside of an estate. So what we're usually talking about in terms of assets owned by the trust are real estate, your house, possibly your second house, mutual funds, stock accounts, bonds, anything that would be solely in your name. Those are the type of assets we want to put into the trust, so that when it's needed to be passed on, the trust document itself says, hey, if I'm not here and my wife's not here, it goes in equal shares to my children. Is there another question?
We are getting someone asking to repeat some of it, but once we get clarification, we'll let you know what part would like to be repeated.
Sure. So by setting up the revocable living trust, it does not impede your ability to buy or sell or transfer assets. It's just done in a different heading. So the revocable living trust is created by you, so you become the settler of it, the one who creates it, and it's generally self-administered, so you're the trustee, and then you get the benefit of what is in the trust. So you get all three elements when you're alive. Upon the death, again, of the surviving spouse, that's when most things are going to take place in terms of distribution under these things. There is no impediment to transferring on to the subsequent beneficiaries. So a trustee is appointed, the successor trustee is appointed, and he follows the trust document. Similarly, if you were selling your property, your home, and you're moving into a condo, say, we simply execute a deed that's called a trustee's deed as opposed to an individual deed. So there's no loss of true ability to control an asset by creating the trust. All right, so what's our next topic there? I'm going to advance it a little bit. So we all know we're all at home, and we may have some time on our hands, and this could be a very good opportunity for you to kind of organize things and take a long look at your estate plan and how to do it. So our estate planning questionnaire allows you to think long and hard about who your agents are going to be, put them down on paper, organize your information regarding your beneficiaries, make sure you have all their addresses and emails and contact information together, identify and locate your assets. You want to make sure that we're not searching under beds or shoe boxes or forgotten about safe deposit accounts to find assets. And then also to give, you can give me a call. My consultations are free. My email is there, and that would be a great thing. I'd love to talk to you more in depth about things. And it is really now a very good time to get these documents taken care of, as we said at the beginning, especially those powers of attorney. If you don't do anything else, if you don't take anything out of here, but that I really implore you to get your POAs taken care of.
Hey,
So
Joe.
yeah.
So we do have another question. Which
Sure.
assets should be placed in the trust? Example, if I have multiple IRAs, can those go into the trust? What about my husband's?
Good question. So those types of assets, IRAs, 401ks, those are unique assets because they are tax deferred. Okay, so they have been growing, compounding without having every year to pay income tax on them. But that doesn't mean the income tax isn't going to come due. It just means it's being deferred and pushed off to when you're in presumably a lower tax bracket, you get to pay the tax. So in IRAs, 401ks, we do not add them as owner directly into the trust. And those can be what we call transferred on death type of assets. So they would not really be included in the trust, because if we change ownership on those assets, the tax becomes due on all the asset, and that's something we do not want to do. Is there any other questions?
Joe, there's a question about if somebody has an older trust. It says, I have a 16-year-old trust, which I need to update.
Yep.
Can I call you and talk to you about redoing a trust or a will?
Sure, absolutely. So again, that's one of the benefits of having the trust is that it doesn't have to be completely redone. It can be amended and updated and renewed. It's always a good idea to to take a look at those documents every few years, 5 years or so. So you're coming up on as your life changes, as we get into different seasons of life. Yeah, it's a really good time to take a look at those documents. And I'd be glad to do that. Absolutely.
Hey, Joe, another question. Once RLT, so Revocable Living Trust, is created and funded, how can additional assets be added at a later date if the assets were acquired after the initial funding? And is it a taxable event?
Okay, good. So you can always add assets to the trust, regardless of when it was created. So for example, if we create the trust at the beginning of marriage here, and then we buy a house, we put the house in there, and then in 15 years we buy a summer house or a lake house, we can put that lake house in there into the same trust. And it's not a taxing event. The only time we're going to be looking at a taxing event is if we start changing 401ks or IRAs or tax deferred type of situations. So again, the beauty of this thing is it lives with you. So you can put assets in at any time. You can take assets out at any time.
Joe, we had a couple questions still. It says, would life insurance policies be included in a trust?
Well, they can be. It all depends on what you want to have happen with the life insurance. Okay, that sounds kind of odd perhaps, but if we're looking to have a life insurance policy fund, say, a special needs trust, which would be a trust created if you have a special needs beneficiary, and you really don't want assets to go into the name of that beneficiary, life insurance can be a valuable tool to fund the trust. So upon your demise, there's a pool of money that would be owned by the trust and then could be distributed to the beneficiaries. Some clients want the life insurance to just remain outside the trust and name their children or their spouse as transfer on death. So it really all depends on what we want to do with the life insurance. But so the answer is yes, it can be, or no, it doesn't have to be.
Another question. Every time you add an asset, does it involve an attorney?
Good question. No. And again, that's one of the other significant benefits of a well thought out and strong estate plan. These are self-administering documents. You may need a quick call to say, hey, did I do this right? But you don't need to come running back to me or any other attorney to make sure that assets are placed into the trust. Like I said, they're self-administering. So I like to counsel my clients that I don't want you to be afraid of this document that you created. I want you to be comfortable with it. Okay, so I want you to be, wherever possible, the one who funds the documents. I'm here for counsel. I'm here to help. But what I don't want to do is create some kind of plan, tell you it's the greatest thing since sliced bread, and then you're afraid to use it. I don't think that's a benefit to anybody. So they are self-administering. You don't need to be running into me every time you add something in. I am not keeping some kind of giant chart of what's in your trust. That's something you do, that you make sure that along with the trust document, that your successor trustee is going to want to know where the what documents are in there, or sorry, what assets are in there.
Joe, another question came in. If you have accounts that are transferable on death, do they need to go into the trust?
Well, again, not necessarily. It all depends on what you want to do with that money. So or that particular asset. So if you just wanted to go to one individual, it does not necessarily have to be in the trust. If you want it to be spread over all your beneficiaries, we may think about doing that. But it really all depends on what we want to do with that asset.
So Joe, another thing that someone had asked was in regards to if the home is held in trust, does it affect your ability to sell your house or refinance your mortgage?
Good. It does not affect your ability to sell your house. So in working with realtor teams, especially Mary and Jason and Shaunna and Megan, we've talked about this a lot. So as they take listings for houses that have already been put into a family revocable living trust, we simply make sure that the listing contract and then the contract to sell identifies the owner as the trust, and that you are acting in your capacity as trustee of the trust. It does not impact your ability to sell the home. It should not impact your ability to refinance your mortgage. One of the things that may happen is that your loan officer is like, I don't know about trust, take it out, it shouldn't be in there. I can counsel loan officers, and we can get things done through the trust, or we can just create a couple of deeds to take your house out, borrow the money, and then put your house back into the trust. That is something we see often, but it's really as a result of a loan officer who doesn't want to take the extra mile for you.
Joe, another question is, I don't understand why, if you can name a beneficiary on a life insurance policy and that doesn't go into probate, why would other assets go into probate if you have a will that names specific money and items to beneficiaries?
Okay. So the transfer on death asset would pass outside of the probate court. You're right. But assets that are not so designated, such as your house, such as stocks and mutual funds and those types of assets, if they're just solely owned individually, they will be subject to the probate court. There will have to be someone appointed to get the financial institution or the ability to sell the real estate. Someone is going to have to be able to act on behalf of the estate. So that is why there would be a probate under the will, because the will is not avoiding anything. The will says, I still own all my stuff. It's the revocable trust that allows you to divest yourself of ownership. So remember when I said at the beginning that the probate court is there to protect your creditors? What we're essentially doing by creating a strong estate plan is that we are avoiding ownership of anything. So you don't have to go into probate court because upon your death, you didn't own anything. Okay, so the trust owned everything and the trust hasn't died. So that is how we avoid probate under these documents. Hopefully that helps clear that question up.
All right, so kind of to piggyback on that maybe, so it says, so you said stocks and mutual funds should be in an RLT, so if you use Merrill Lynch for your mutual funds and stocks, then you would put that into the trust?
Correct. So the Merrill Lynch account would simply be transferred from you individually over to ownership by your family trust. It's not something that the financial institution would be unfamiliar with. Every financial institution has their own type of forms and requirements to do this, but it's not new. It's not a surprise. It's not some kind of well, boy, I don't know how to do that, Mr. Jones. It's okay. That sounds great. It's a really good idea that you did this. This is what I need from you. I need this form filled out. I need a copy of the trust. I may need a certificate of trust. And then we get that asset put in to the name of the trust, so that when we die, that when the surviving spouse dies, the financial institution is like, okay, well, we're ready for it. Who does it go to?
Joe, just for our last, while we wrap up here, we have a couple more minutes. In regards to guardianship, can you touch a little bit on that? I know you and I have had private discussions in regards to, I was shocked for you to say that you really should only name one guardian and try to avoid a couple of sorts.
Yes. And I counsel clients mostly to name the blood relation. So, yes, I want my sister to raise my children. And I love my sister and her husband. So it's a good idea to name the sister as the guardian. It's not necessarily a great idea to name the sister and the husband, because if down the road things aren't quite so great and the non-blood relation is on the will as a guardian, they would be a co-guardian, even though that's clearly not what you really wanted. So it really kind of gets back to my idea of trying to avoid co-designations wherever you can, because it can complicate things, not only from an administrative aspect, but from a guardianship aspect. Clearly, the last thing you wanted to do was have your children raised by someone who's not a family member. So they can be delicate conversations. I'm not saying it's easy, and most of my clients, especially my younger clients who have young children, this is the stumbling block. Well, I always have thought they'd go to my brothers, and my wife was like, well, they're going to my sister. So I'm not saying they're easy conversations to have, but they're necessary conversations to have. Does that help?
Totally helps.
Good. Do we have anything else today?
I don't see any other questions there. I think we just want to thank everyone for coming.
Absolutely.
And being patient with us too, since this is our first time through the process. Yes. And feel free to reach out to Joe for questions specifically, or any of us agents. We're happy to connect you with Joe or give you further information. I think Jason had said at the beginning, we are recording the session. So we're happy to send out links, because I know it's a lot of information. So for you to be able to go back and review, or also feel free to share it with anybody you know may have interest.